மதுரை மாவட்ட நீதிமன்றத்தில் கூடுதல் நீதிமன்ற கட்டடங்கள் அமைப்பதற்கான அடிக்கல் நாட்டு விழாவினை உச்சநீதிமன்ற தலைமை நீதிபதி சந்திரசூட் அடிக்கல் நாட்டி வைத்து உரையாற்றி வருகிறார். அது நேரடி காட்சிகளை தற்போது பார்க்கலாம்.
There are no washrooms for lawyers and for lady judges, women judges. Studies have shown that a comfortable working environment enhances the work output. I hope that the administration consults all stakeholders and caters to their spatial requirements before commencing the construction of the building. When the former Chief Justice of India visited Chennai a year ago, Thiru M.K. Stalin put forth 3 points for consideration. The first was for the setting up of regional benches, which the Honorable Chief Minister again referred to a short while ago. The second for introducing Tamil as the official language in the High Court. And the third, ensuring inclusivity as a principal factor in making recommendations for the appointment of judges. I would like to use this stage to speak to you about all the endeavors of the Office of the Chief Justice of India in addressing these 3 concerns. I have been striving to ensure access to the Supreme Court for lawyers and law students who do not reside in Delhi. I always say that the Supreme Court of India is not the Supreme Court of Tilak Marg, but it is the Supreme Court of the entire nation. We have introduced a hybrid system by which lawyers can appear before the Supreme Court both physically and virtually. This facility enables the seamless connection between a judge sitting at Tilak Marg in Delhi and an advocate residing in Melur or Virudhunagar. Additionally, we have started live streaming all constitution bench cases. This provides students from government law colleges in Madurai or Trichy the opportunity to watch Supreme Court proceedings and to be educated about the way the law is evolved, developed by the Supreme Court. While many law students in Tamil Nadu may be unable to pursue an internship in Delhi, owing to the distance and limitations on economic capacities, I am confident that access to the court proceedings would substantially bridge the opportunity barrier. I must share with you certain facts which may otherwise not be known. During the course of the COVID-19 pandemic, 2.62 crore cases were heard by the High Courts and the District Judiciary on video conferencing. 78 lakhs in the High Courts and 1.84 cases in the District Judiciary. The Supreme Court from 23rd March 2020 till 13th February 2023 heard 4,13,537 cases through video conferencing. The use of this modern technology has enabled us to reach out to our citizens. Lawyers in the Supreme Court who appear before us are unquestionably the leaders of the profession in Delhi, but equally the base of the pyramid in the legal profession comes from lawyers from socially and economically marginalized backgrounds. The tip of the iceberg is very small. The base is what defines the identity of the legal profession. The clients are in day-to-day touch with lawyers from the district judiciary. When a second appeal comes to the High Court, the client in the districts is in direct touch with the arguing advocate in the High Court or through the intermediary of the High Court who has conducted, the lawyer who has conducted the first appeal. Opening up the facilities of the Supreme Court to lawyers not merely from the centers where the courts are situated, such as Chennai, but lawyers from all over the country, from the districts, would enable a reduction of the cost, because a lawyer in the district judiciary charge a fraction of what is charged by a lawyer in the high echelons of the system. But there is a great deal of confidence which the citizen has in the lawyer who has conducted the case in the forum where the case was instituted. So our effort in the Supreme Court is to use technology to truly make ours as a national court where we can hear the voices of our citizens through lawyers who have an intimate connection with their lives, who know the social conditions in which these social problems which are brought before the court emanate. With respect to the second point of enabling the use of Tamil as an official language in the High Court, perhaps a constitutional amendment would be necessitated having due regard to the provisions of Article 348 of the Constitution. I am cognizant of the language barrier and the ensuing impact of this barrier on opportunities to young graduates. English is not our first language. We think and formulate our thoughts in our mother tongues. However, I implore all young lawyers who are facing some difficulty with communication in English not to be demotivated. I request the judges of the Madras High Court to be encouraging towards the young juniors and not let language barriers impede effective representation. I was Chief Justice of the Allahabad High Court for a period of nearly 3 years. A young lawyer would open the case by saying, "May it please your lordships," the old colonial form. But the English advocacy very often ended with saying that. The rest of it was conducted in the mother tongue of the lawyer. I belong to Mumbai, and my knowledge of Hindi was deeply influenced by Marathi, my mother tongue. But I found that speaking to the lawyers in their mother tongue brought me in very close connect with the members of the bar. They did not ridicule me for the errors which I would sometimes make in expressing myself in their mother tongue. But they appreciated the fact that a genuine effort was being made to connect with lawyers so as to make them comfortable in the language of discourse in the courts. Because when litigants and lawyers are comfortable with the language of the discourse, they can present their viewpoints fearlessly and effectively. So we as judges must encourage the youngsters at the bar and help them build confidence in communication. In an attempt to localize the justice delivery system and bring it closer to the citizens, we have started translating judgments of the Supreme Court in other official languages recognized by the Indian Constitution, including Tamil, with the aid of artificial intelligence. I hope that this initiative will go a long way in not only bringing the court closer to the citizens, but would also help lawyers who are not conversant with the English language to keep up with the developments in law. Since independence, there are 34,586 judgments of the Supreme Court, all written in English. Our judgments were being made available to our citizens by private law publishers for whom you had to pay a subscription.